Senator Schumer, myself, and yourself signed a letter to the chairman of the full committee asking for hearings, and I'm glad that your subcommittee is leading on this, and I understand the chairman is going to broaden some of his call for hearings and include this topic. So this is extraordinarily important. Ms. Rich, I have two particular lines that I want to pursue. I think Senator Warren opened the door to something I think is incredibly important, which is what role should the FTC and the federal government create in standards? It seems to me that whatever high standard exists in the marketplace readily available in technology is one that we would want to have companies follow in order to ensure the security of millions of Americans' private information, critical information to themselves, to their credit histories, to retailers, to banking institutions. And so if a company, if we set a standard that basically says, look what's available in the marketplace, we can't expect a company that gets hacked and was already using the highest standards available in the marketplace to be held responsible. But if, in fact, there was a standard that was available and that company or companies were not using that standard, then we have to question whether or not they made an investment decision not to go ahead and expend the resources for that higher standard. So it seems to me that part of the question is, and I know that the private sector has largely worked on creating its own standards, but is there a role for the Federal Trade Commission and the federal government to set a standard that says, look, whatever is existing in the marketplace that in fact can be achieved to give the highest protection available should be the standard, and if you don't pursue that standard, then you are subject to consequences thereof?
Well, that's incredibly similar to the way we think about it now when we talk about having reasonable security. So reasonable security means you take into account what the risks are in your business, what the sensitivity of information you collect, how much information you collect, and the cost and availability of measures that are out there in the marketplace. So that's exactly how we analyze it. And the question
is, does the industry understand that they're going to be held to those standards? Because I don't get the sense that there is an obligation, per se, to be held to that higher standard.
Well, one of the limitations we have in our work is we don't have civil penalties or the kind of sanctions that are needed to provide the right incentives to focus on this issue.
But if we set I want to get to civil penalties in a moment, because I sent a letter to your chairwoman and she responded to me in that respect. If we set a standard, then at least everybody has notice. Here's what we expect of you. If we don't set a standard, then we have a more amorphous process of deciding what is the right standard or not. And of course, we should have industry input into that standard, but it seems to me that we should be setting a standard, because if we set a standard, then we have notice, the essence of due process, notice, an opportunity to be heard, and then we go away with a standard. So I'd like to pursue with the agency whether or not such a standard is important, Mr. Chairman. And secondly, with reference to additional authorities, in my letter to Chairwoman Ramirez asking about the Commission's efforts in the past, I noticed that there were never civil penalties, even though they were very large breaches, not as large as this one now, but large for their time. And it seems to me that she agreed that the authority to impose civil penalties would be a helpful tool to have, in addition to current authorities like consumer restitution and disgorgement of ill-gotten gains. I don't think that's something that you want to levy against every company. I think that goes back to the standard. If you have the standard and you're pursuing the standard, you shouldn't be subject to penalty. If you have a standard, you're not pursuing the standard, then civil penalties may be an option. Do you agree with that line of thinking?
It's very important to have civil penalties as an available remedy to make sure there's both specific and general deterrence when there's been a failure.
Okay. And the reason, if I can, Mr. Chairman, finally, you know, your testimony reasserts the Federal Trade Commission's long-standing assertion borne out through case history that Section 5 of the FTC Act covers instances where a company fails to adequately protect consumer data. This assertion is based on the common-sense premise that customers have an understanding that companies will take reasonable steps to protect their data, and failure to do so would be an unfair or deceptive practice. However, Such companies as LabMD and Wyndham Worldwide have been challenging this assertion. So I think that if that's the case, that now they're going to challenge that assertion, it seems to me to call for not just voluntary efforts, but to create a standard and consequences of that standard that can give Americans the best security that they can hope for. And I look forward to working with the committee and with the FTC in that regard. Chip and pin technology, which has been around more than a decade. It's widely used in Western Europe and other areas outside the United States. So I see that several of you in your testimony cautioned against adopting a similar standard by law that would lock in any specific technology. However, even if we don't adopt a federal legal standard that favors one technology over another, couldn't we still have a standard based on performance? In other words, at what point should it be considered an unreasonable security risk for a company not to be using chip and pin technology or something that performs equivalently? Mr. Zawinski?
Well, Senator, I think my testimony, we definitely say we shouldn't adopt a specific standard, but I certainly think, from what I understand, and I'm not the world's biggest expert on the tech, that chip and pin is a higher standard than chip and signature. So if you have a technology forcing standard, a performance standard that chip and pin meets, I think that's a good way to go, as long as it's an open standard that encourages more and better technology to come forward.
What about the banks and the retailers?
You know, the setting a specific technology standard, I would agree, is not a good idea because of how quickly the fraudsters keep changing and adapting. But as far as setting standards that we all do the best we can with the technology available, I think that that's fine.
We would like our partners in this to do the right thing and to adopt pin and chip technology. However, as I mentioned earlier, a number of retailers are already beginning to explore mobile as a possibility. And we want to be careful that Congress would not do something that might slow down that transition to even more secure systems in the future.
Yeah, well, that's why I'm saying not supporting a specific standard. I get the sense everybody's worried about what Congress will do. We're worried about what you all do. I sit here and listen to the banks say retailers should have more liability. I sit here and listen to the retailers. Banks should have more liability. In the interim, the only entity that potentially is getting screwed with all of their financial data and security is consumers. So we have to have a different paradigm as to how we get here. And so it seems to me, as I was posing the questions to the Federal Trade Commission representative before, that creating some type of standard that doesn't necessarily lock you into a technology that may be in time, you know, a dinosaur, but does ultimately create a standard of responsibility is important for both the banks and the retailers at the end of the day. Now, I know that the industry, the card industry, likes setting its own standards. I understand why. But at some point, there is a responsibility here to the consumers and to the economy, because it's not good for retailers. It's not good for banks when we have data breaches at the end of the day. And it's not good for the card companies in terms of the confidence in people who put it on their credit card. So I'd like to hear from Mr. Mrozwinski. You ask in your testimony whether federal regulators should have a greater role in setting security standards. And Mr. Reuter, in your testimony, you raised the question of whether we should have a national standard that applies by force of law versus simply by the force of contract to all parties in the chain of possession of consumer financial and payments data. Isn't that really part of the goal here, so that we can have a standard that then can be applied and that ultimately we can make judgments? Look, if you met that standard and there's a data breach, well, there's nothing more you could do. I mean, you know, you did all the things that you could. But if you don't have a standard, we never know what is the right engagement by both the banks and the retailers in protection of consumers.
Well, Senator, I understand that you're conducting an ongoing series of hearings. On Thursday, the regulators are coming in, and I think it's useful to ask them, should there be a federal performance standard, as you point out, a federal performance standard that's enforceable by the regulators. Should the regulators have the authority to look at, and maybe they do already, and maybe they're already doing something here, but they haven't told me about it, shouldn't they have the authority to determine whether any industry standards body, any voluntary industry standards body, is performing adequately to protect the safety and soundness of the financial system? So yes, I agree.
Yes, Mr. Ward.
Senator, we as a banking institution already have to comply with a number of data security standards in the Gramm-Leach-Bliley Act. It's not only something that is written and we have incident response, but we're examined on a regular basis. So as an industry, that's why we're not opposed to setting standards. We're already obligated to follow standards today.
And that may be different than what the Federal Trade Commission might determine would be the standard more broadly, but I appreciate that in Gramm-Leach-Bliley. May I have one other question, Mr. Chairman, one final question? And it goes to you, Mr. Winsinski, as a consumer advocate here. You know, we have seen an economy that is increasingly data-driven in terms of companies collecting, storing, processing even greater quantities of consumer information, often against consumers' wishes or even without their knowledge. Financial service industry, for example, we hear stories about lenders data mining sources like social media to help them form underwriting decisions on consumer loans. Companies aggregate more data. The consequences of a breach or improper use become greater as the risks expand beyond simple fraud to identity theft and other hardships. Target experienced breaches of at least two kinds of customer information: payment card data and personal information such as names, email addresses, and phone numbers. What if the next breach also involves information like purchase histories or Social Security numbers? So my question is, are you concerned about the rise of big data, and what can we do to give consumers greater control over their data, reduce the chances of a breach, and minimize the harm to consumers if a breach occurs? And should we be putting limits on what companies can store without a consumer's affirmative opt-in?
Well, Senator, you've raised a question that I could talk about for about an hour, 2 hours.
I'm sure the chairman wouldn't want you to do that. But
I won't. But at the end of my testimony, I refer to a recent Federal Trade Commission comprehensive report on privacy, and also to a law review paper that I've written on this very subject of big data being used for financial decision-making. And as Mr. Duncan pointed out, much of the big data that has been collected is now starting to be collected in mobile landscape as well. So in addition to credit card information, in addition to personal information about the kinds of things that you buy with your cards, we've also now know where you are and what you're doing at any particular time. And that new locational data is something that I think Congress should look at as well. But I'd be very happy to talk to you about this Internet ecosystem. It used to be you had a bank, and you had a merchant, and you had a credit bureau that had information about you. And there were direct marketing companies, to be sure, but they didn't have very much information and they weren't connected. There are hundreds of interconnected, if not thousands, of interconnected business-to-business companies on the Internet buying and selling information about you today and auctioning you off in real time to the highest bidder. Many of them are predatory lenders, the highest bidders. There are companies on the Internet called lead generator sites that I would encourage the committee to just hold a hearing on lead generation. You type, "I want a loan" on the Internet, you're taken to a site that just bids you out to the highest bidder, not the lowest bidder, the highest bidder. So there's a lot of work that needs to be done. Consumers need greater rights. There are some bills that address parts of it, and we'd be happy to talk further on it.
Chairman, I can see that there can be some value, even to consumers, to have some degree of information. But by the same token, I am increasingly concerned about the degree, the depth, the breadth, and scope of where that information is. And finding the right balance here, I think, is incredibly important. I thank the chair for their indulgence.